Mr. Griffiths, is there something funny? They want to kill my client. That's what we're playing with his life.
Stop, wait. Devins has now been in custody for 2,202 days, okay? And
outside of them.
Judge, he's actually lying to the court right now. I found it out.
It's absurd. I'm embarrassed for both sides. I'm embarrassed.
And it was
You went to trial.
Yes.
This is the decedent's cell phone.
And now, 2 years later, I'm being accused of trying to kill Danny Polo.
YNW Melly appeared in court for motions. Melly's lawyer, Raven Liberty, is being accused of trying to kill Detective Danny Polo. What I just said is not a joke. Raven Liberty explains to the judge why she thinks the search warrants were executed, and she says it's because of that. Thank God this judge is set on the September 10th trial date, and he's not budging whatsoever. So that is set in stone, and everyone else has to figure everything else out. Hit subscribe, let's get right into this. Let's go. All right, here comes Melly walking in. Doesn't look happy. Understandable. Was it 2,100 days in jail? Shaking his head.
2, motion limited to exclude James Howard to relevant and immaterial detention communication. Motion limited to exclude a relevant and immaterial TikTok video of meat baby. 4, renewed motion to take deposition of Christine Bradley.
Hearing a judge say Neek baby, whatever that is, I think it's a TikTok username that made a random video that the state submitted as evidence.
Defendant's motion to strike from the alternative response to the state of Florida's motion to allow former testimony of Felicia Holmes. That's what I wanted to get done today. State, I'm being told that there's a medical issue with Ms. Buckley, is that correct?
That's correct, Judge. My understanding was the course of a a notice of hearing deadline was Friday 5 p.m. It was moved to Friday 9 p.m. because Ms. Liberty was stuck in court and needed time to prepare it. The notice was not actually filed until Saturday, so they failed to comply with the court's requirements. So at this point, the state's position is no notice of hearing was properly filed and there's nothing to be heard today.
Does the state want this trial to happen? He's saying that she was late like 12 hours. Like she filed it on Saturday and it was supposed to be Friday evening. Do these f***ers want this trial to go on? Like this is f***ing insane. He just said they don't want any motions to be discussed. Are you f***ing kidding me, dude?
What do you want me doing?
Judge says so you don't want to do anything today. What the fuck?
The funny thing is, the great thing about those cameras in this room is everything gets recorded. I did say Friday at 9, and then I actually stepped back because I knew I was setting myself up for failure. And I said, well, I do it Saturday. Taylor then responds, oh, as long as we get it before the beginning of the next business day, which is Monday. So they've had it. Most of these motions, Judge, were filed for over a year. I will bring the court's attention because last night in preparation of this. I know the last time we were before, they objected then about hearing motions because they were filed under the tampering case. Yet they filed several different motions saying it doesn't matter what case number are on the motions because the discovery is interchangeable. I'm quoting exactly the language from their own motion. So it's good for them when it's convenient, and now it's not convenient, so there's another excuse. It's been a year. Everything was properly noticed. I will also add, there's no written order setting a filing deadline or allowing them to file a response within a certain time frame. That was oral. So as we all know, oral orders don't count for anything. They need to be written. There was no written order. I did ask to extend it. We are ready to go forward. There are 2 state attorneys sitting over there. Understandable. One of them is missing. Mr. Griffiths, is there something funny?
There'll be no attorney.
She says there's something funny.
You can direct your comments to me.
Okay.
All right, y'all
So
have
we're
5
ready.
years to talk to each other about this.
We're ready
You
to
just
go
talk.
for it, Judge.
Okay. Listen, State, I get what's going on. I'm not going to put anyone on the gun here, but I read all these and I went through the entire court file in preparation for the hearing today. Most of these are fairly straightforward. Over your objection, I'm going to hear them, but if we get to some specific factual issue that you say only Ms. Buckley has the particular knowledge to
Oh, Buckaloo's not there. That's their f***ing fault. This is a hearing that's been scheduled for weeks. Oh my God, just because Miss Buckaloo's not there, that's so annoying.
address, you can certainly tell me that. But again, I find most of these to be very straightforward. Ms. Liberty, I went on CMS yesterday and I went on Odyssey. I can't find any court order dated February 9th, 2024. Well, I'm just looking at Judge Murphy's order. He said this order is related to the motion to compel discovery filed on February 6th, 2024.
So there should be 2 motions for rehearings filed by the state.
So the reason why he is all confused, the judge, is because he's a new judge in this case, and they're trying to find orders and motions. He's struggling to find right now in Odyssey or whatever the system where they find all that.
Number 2 is defendant Jamel Demon's motion in limine to exclude James Howard's irrelevant and immaterial detention communication.
This is the 600 jail calls with someone named James Howard. I'm not joking or over-exaggerating. It was actually 600. Apparently, he only says the name Melly once out of 600 phone calls, and it's about talking to Melly in jail or something. Defense obviously is saying this is bullshit and irrelevant. I don't know why the state was so horny for it, but...
So you're talking about, this is a motion limited for trial. And I read the motion. Anything else you want to tell me in support of your motion, Wilson?
This judge, it was close to, I want to say 84 hours worth of phone calls.
Holy shit. 84 hours of phone calls one of them had to sit through.
That were given to us that December. We were set for trial. I was always of the position it was given to us that late in the game in order to make it continue it. Nonetheless, I had a group of students go through those phone calls along with myself and the investigator. When you look at the police report that was authored by Garrett Steele, investigation was being done by Polo into this James Howard, and I believe that all would be. For some reason then references James Howard in this police report, saying he was listening to phone calls by James Howard, and then he hears James Howard telling somebody on the phone call that he has to do something from Melly that day. We had the opportunity to depose Detective Polo as well.
So it's Danny Polo that was listening to James Howard jail calls and heard this.
I asked him this very question. I told him over 80 hours worth of phone calls. There was one phone call, and that one phone call in this batch of phone calls tells us nothing other than him saying, oh, I have to talk to Melly today. Now I have to do something for him. Now I got to call people for him. Nothing at all. During the deposition of Detective Polo, when I started questioning him, hey, I went through all these phone calls. Could you please direct me to what phone call I should be looking at? What batch of phone calls? He then tells me, it's not this batch of phone calls. It's a batch of phone calls that would go back to 2020 and 2021. We are dealing with the tampering, I believe we're spanning from April of 2023 until August of 2023, somewhere in that time frame. Detective Polo, in his own words, was the only time that he had heard James Howard talking about Melly, would have predated the incident, i.e. 2020, 2021. Nonetheless, those phone calls are not in this 84 hours of phone calls.
Dave, can you respond?
Yeah, the board would see on that, there's still the outstanding issue whether Mr. Devin still wants to celebrate representing him. The state has raised the issue with the conflict of interest. The court has pointed that out. That was going to be one of the first things we were going to address in June today, and we still need to address that because obviously if he does not want to celebrate representing him, then there's an issue to that argue the motion.
Oh my God. See, now the state didn't even respond to the motion. They're just saying we need to figure out if Miss Liberty on the right here is still going to be Melly's lawyer because they think she can't be his lawyer anymore. They don't want her as his lawyer. They literally submitted a whole motion saying that.
I already had that discussion, so I'm sure if there's something that you want to let me know, you're going to let me know.
Yes, sir. The state filed a written response, I believe it was yesterday. This is one that was fuckily prepared, but as pointed out in the argument, the state is not required to disclose which calls it intends to use in trial. But other than that, we are going to rely on the responses.
Isn't that so f***ing crazy? The state is not required to specify which calls out of 80 hours of calls they're going to use.
So I did check the docket this morning. I saw no written motion. And it's funny, Judge, that they were starting this hearing off saying they wanted to continue it because they didn't get proper notice. A notice of hearing from, I don't know, almost 2 weeks ago. But in the evening, they filed something before Ms. Buckley went to the hospital.
This is the second time. You need to look at me and address things to me. Okay? I could give you a lot of adjectives about what I think of this entire procedure. Funny is not going to be one.
Okay.
So anything else you want to tell me about this?
No, Judge, I would say there are no material phone calls that would even go to the nexus of witness number.
Judge is getting annoyed. He's saying this shit's not funny. Bro said he got a lot of other adjectives in mind.
So, this one, and I'll enter the appropriate orders going to be denied without prejudice. I have no idea what is or what is not going to be relevant.
By now, you've probably heard of DeepSeek. It's now the #1 app on most app stores. But every conversation you have through their app gets stored on Chinese servers and is subject to Chinese censorship. If you want to test out DeepSeek's power without sharing every conversation you have with Beijing, then let me recommend my sponsor, Venice AI. Venice.ai is a generative AI platform that is private and permissionless. They utilize leading open source AI models to deliver text, code, and image generation to your web browser. There's no downloads and no installations of anything. Venice AI was able to edit it so it's private and has no censorship or bias injection. We also know that these companies program their AIs to only give certain kinds of answers, so I love that Venice.ai doesn't spy on you or censor AI. Messages are encrypted and your conversations are only stored in your browser. Here's Venice.ai's website. I'm asking what's the latest update in the YNW Melly trial, and look at this beautiful description of everything that's going on in the YNW Melly trial right here. Several delays, motions filed by the prosecutors and defense attorneys. It also even points out the appeal situation going on. I like to ask Venice.ai random questions throughout the day. Anything that I need figured out quickly, it's pretty convenient. If you want to try Venice.ai, you don't even need to create an account. You can just go to my link, venice.ai/CUFBOYS, and start chatting. And if you want access to a completely private and censorship-less DeepSeek model and other amazing features, you can use my link, venice.ai/CUFBOYS, and use code CUFBOYS to get 20% off your pro plan. Thank you guys, back to the video.
There's no way that I could. I can't make the state try their case in a vacuum. But just without prejudice, you can certainly raise the issue if the state tries to introduce any of these phone calls at trial. The appropriate objection, and I'll give you the appropriate ruling. But in a vacuum, having never heard any of these calls, I have no idea what the calls are, nor do I have any idea what the evidence is going to be at the trial. So that one's going to be denied without prejudice.
So he denies that first one.
All of these, it would be the same thing. I don't know what the evidence is going to be at the trial. There's actually already been a trial, and the evidence may be the same as the first trial, or it may be completely different. I have no idea. But I can't make a decision now without there being one witness, without being one piece of evidence, without hearing the answer of one question in anyone's testimony. You may be right. These things may be not relevant, and the state may not even try to introduce them. But I can't give you a pretrial ruling, again, in a vacuum when I haven't heard it.
This video is after the homicide. I don't even believe the individual in the video doesn't even know Mr. Dennis. So there is no relevancy to the homicide and my client. If it was filed, I guess, because they have it interchangeably with the tampering, there is no, I guess the tampering in this case would be Mariah Hamilton. There is no evidence in that video of Mariah Hamilton. There is no evidence in that video of anything, period, that has to do with this tampering case or this homicide case. I believe it is the state's burden at this juncture, not our burden. It's not relevant, period.
I don't agree with you. It's not the state's burden. This isn't the trial. So, state, anything you want to tell me?
No, we would ask Your Honor to defer ruling depending on whether or not it comes up at trial. Depending on the evidence, it may become irrelevant once I provide it, and we can't tell you at this time that we can, because we can't say we don't. We provide it to defense, and should it become relevant at trial, it will be subject to all appropriate relevancy objections, and we can address it then.
Thank you. So for this one, I'll enter a written order. Again, the defense motion is denied without prejudice.
Denying all these until the trial starts, pretty much.
Number 4, renewed motion to take the deposition of Christine Bradley.
Emails, they get even more confusing. Your lead detective on this case, Garrett Steele, said under oath that he never read these emails. These emails are referenced throughout the affidavit and the arrest, stating that the deposition and these emails proved there was an official proceeding that Mariah Hamilton did not go to. Again, Garrett Steele said he never read the emails. Danny Polo then says it's not his case and he can't comment on the emails. It's really unclear from reading them what's happening. And again, there were certain emails that were not even provided that we later were given from other sources.
State your response.
First, that's an inaccurate statement. The emails were actually provided. That's actually in the state's response to one of Ms. Liberty's other motions, but turning specifically to this one, the state filed a response back on January 2nd of 2024. We're relying on that response.
Defense wants to depose Christine Bradley, who is the former prosecutor in this case that got kicked off from the first trial.
State, let me ask you this. Is Ms. Bradley listed as a witness?
No.
She's not. You're not going to call her.
No.
Yeah, she listed by you all as a witness?
Yes, Judge.
So the defense lists a witness, you choose the rules, and if you intend to call them.
Yes.
So,
Interesting. That will be fucking crazy if they call the former prosecutor as a defense witness. Oh no, dude.
We do intend on calling her as a witness, because she has, I believe, been deposed as far as, or correct me if I'm wrong, as far as the other issue before she testified. Anybody? No. All right. She wasn't there. I want to
tell me what you need to,
very
give me a couple questions you want to ask her.
I want to get to what other emails were there that she had between Christopher Barris, showing the efforts to get Mariah Hamilton to this deposition.
So with Ms. Hamilton, that's the person who just got put on an ankle monitor.
Yes, we need some clarification from the previous state attorney when you talk about these efforts to get her to deposition. And then we are provided emails, and those emails tell us something totally different than what's being
Is Ms.
proffered
Bradley
for.
listed as a witness in the 23 case? She is not. Is she listed by you as a witness in the 23 case?
Not at this juncture, they took the appeal before we got that far. And this, again, was the motion that was pending, coming up to getting a
Well, do you want to ask her questions about the homicides, or do you want to ask her questions about the tampering?
about the tampering.
And she's not listed as a witness in either one, by either side in that case?
Okay, so with the tampering, this motion had initially been filed. We hadn't got to the point where we were going to do, I had not did a witness list yet on the tampering. She is listed, however, on the homicide.
You?
Yes.
Defense is trying to get to the bottom of some clarification with emails, and they think they're lying about something with Christine Bradley, the former prosecutor.
I can take depositions of anybody with relevant information, which Ms. Bradley is, whether she's
Yeah, I
listed
agree. So
or not
what do you
listed.
need?
Because they filed a protective order and won't allow me to do it. That's why I had to then file the first motion.
But then the next sentence says, after received by the defendant of the discovery exhibit, the defendant may, again, without leave of court, take the deposition of any unlisted witness who may have information relevant to the offense charge. So you don't think it's your deposition?
Except for the fact that Judge, she is a state attorney, her role as state attorney, she was a public self-protection, she filed a protective order, in part because everything that Ms. Liberty is asking for has been turned over. Emails, whatever else that she's been looking for, has been turned over, I believe actually several times by Ms. Buckaloo, again, which is one of the issues going forward today, not having her here, but she was the one that provided copies of everything.
Well, she's not assistant state attorney assigned in this case.
Ms. Bradley? No, she's still,
What's the problem?
it's no different than if somebody is a case filer or works on a case. There are work product protections involved in terms of what Ms. Liberty intends to ask. And we sought that protective order because she's entitled to those protections as a prosecutor, and also because, based upon our response, that it is unnecessary. I'm sorry.
I guess that's where Ms. Liberty, I'm still not following what the relevance is. Tell me what, let's say she wrote 1,000 emails back and forth. What is the relevance?
Because if you go to the,
So it's emails between Christine Bradley and Mariah Hamilton's lawyer. It's a great question. I don't know if it's relevant or not, but
because if you go to the arrest affidavit, under the witness tampering, these emails that Ms. Bradley authored are specifically referenced in Garrett Steele's police report, right? He says that he reviewed emails between Christine Bradley and defense counsel coordinating the deposition of Mariah Hamilton, that she showed her numerous attempts to get Mariah Hamilton to this deposition. That is Garrett Steele's words. We deposed him. I put it in the motion. Garrett Steele then says, I never read a single email. I'm depending
But I
on
mean,
him.
his report's not going to be in front of the jury. I mean, none of that's going to be in front of
It is relevant to these emails because it is part and parcel of everything of the basis of arresting Mr. Dennis. They weren't saying Mariah Hamilton didn't show up to trial. They said Mariah Hamilton didn't show up to a deposition. The other reason I need to depose Christine Bradley because it's really important how that May 5th date was given, all right? So when we're trying to go with the premise that my client tampered with Mariah Hamilton because she didn't go up to this deposition, we need to hear from Christine Bradley and find out what efforts she made to coordinate this deposition with Christopher Barris. That is why she was also supposed to turn over these emails. And guess what? When you read these emails that get turned over, Stuart Adelstein's emailing with Ms. Bradley. trying to ask for dates for the deposition. There was not one single email that was provided to us in Ms. Buckley's response from the time that Christine Bradley gives us dates to the time that Stewart picks them. She was not contacting Mr. Ferris. That is, we can't see that at all from her emails. We finally get an email from her, April 18th, that's copying an email from April 17th. That appears to be the first email that she sent to Christopher Ferris about this deposition. So for the state to not coordinate a deposition with a witness and then to cover up their negligence, turn around and file a criminal charge against the defendant, when in reality, if we got her up there, we would hear from Miss Bradley that she never properly coordinated this deposition, that she never told Christopher Ferris. And all the months leading up to us trying to schedule this, Mr. Ferris, from these emails, was never contacted. And that's what we need to depose her about.
So defense thinks that Bradley lied about trying to put effort in getting to depose Mariah Hamilton. That's the whole point of this.
There is an email in here also that was provided where she talks about numerous phone calls and text messages that were sent to Mr. Ferris. I don't see those. We don't see the numerous text messages. We don't see the numerous phone calls. So we need to depose her on this limited subject of what she did. When I asked him under the statute, tell me what official proceeding is, he goes outside of the statute and tells me anything that's involved with the lawyer, that's an official proceeding. That's your lead detective. They want to kill my client. That's what we're playing with, his life.
Stop, wait. You just told me this has to do with the tampering case. No one's getting the death penalty for the tampering case.
Yeah, but they want
Ms.
life.
Bradley's testimony in the murder case is wholly irrelevant, so.
They want
Let's
life
go
in
back. Are
prison.
we talking about the tampering case, or are we talking about the?
We are talking
outside
about the
case?
tampering, but they're also intermingled with each other. So it's life in prison.
Okay, I got
Tampering.
it. Respectfully, over the defense objection, renewed motion to take the deposition of Christian Bradley.
Shoots that one down quick. She said they're trying to kill my client. That was intense.
Find that her testimony would be relevant in any way, shape, or form. It's not relevant in a homicide case, nor do I find that it's necessary under what's been followed with a tampering case of information or what's required to be proven pursuant to the jury instructions. But you're telling me you listed her as a witness, that means you have a good faith belief that you're going to call her as a witness, so you can call her as a witness. Ask whatever questions you want from the jury under oath, but that one's going to be denied. Defendant's motion to strike and/or in the alternative response to the state of Florida's motion to allow former testimony of Felicia Holmes. So this kind of mirrors the same as 2 or 3. I mean, I have no idea if Felicia Holmes is going to, she testified at the first
She
trial,
testified
right?
at the previous trial, Judge. We actually started to address this motion at the previous hearing on Judge Murphy. Ms. Allenstein actually put a stop to it because he brought up the issue that the court has brought up, which is until she actually takes the stand, we're not, outside the presence of the jury, we're not actually going to know what she's going to do. She has filed through her attorney a notice of her right to invoke her Fifth Amendment privilege. And I believe when she was in court, she was either going to say she was going to invoke her Fifth or say that she didn't remember. But I think what's going to end up happening, as Mr. Allenstein suggested at the previous hearing, once we get her as a witness at the trial, she'll be brought in outside the presence of the jury, and then we'll have to conduct the inquiry.
So you want me to defer on this until we have a proffer from her? And
Correct. We obviously anticipate her invoking or saying she has no memory, but until it actually happens, I mean, she might not show up, which is another issue, which we might then saw.
She's on a bracelet, but she'll show up where they'll have her arrested.
Okay.
Right, but until we reach that point.
Anything else you want
Yeah,
to tell me
but
about?
they filed this motion, as I put forth in my motion to strike. Actually, when Bradley filed it, they incorporated it. They have not withdrawn it, so it's their intentions to move forward. Mr. Griffiths is correct. She does have to show up here and testify. That's why I put that email there that Ms. Bradley sent. But that email is sent the day before this motion is filed, saying what? I've done all the research, and from my research, it shows that Ms. Holmes would have to show up to court and plead the Fifth. I'll file the motion if she shows up to court and pleads the Fifth, and then she doesn't have to come back here anymore. I find it disingenuous and unethical for the state attorney to be advising a witness to plead the Fifth on the stand, much less advising them how to testify whatsoever.
Didn't she have her own lawyer?
She has her own lawyer, Mr. Barris.
You're not giving her.
I'm certainly not giving her any advice.
Go ahead.
But that is Ms. Bradley.
Ms. Bradley is no longer
Ms.
the
Barris, but you are moving forward on her motion. So that is Ms. Bradley telling Mr. Barris that your client needs to show up and plead the fifth. So now Mr. Griffiths is saying, oh, we are going to move forward, but she needs to show up and she needs to plead the fifth. If it's his intention and he knows that she's going to plead the fifth, it's not proper to bring that up in trial or in front of the jury.
Well, I agree. I mean, that won't happen in front of the jury.
So what it sounds like is he's actually agreeing, judges, they're not going to be moving forward their motion to have her deemed unavailable if they plan on having
I
her
don't
come to
know.
court. So I moved to strike the motion
Okay.
because it
So-
seems that's what they're saying themselves.
I'll defer on your motion at this point.
Defers the Ms. Holmes motion.
Okay, number 6, motion for scheduling order. At the end of the day, I consider this more of a professional courtesy. If the parties want to be courteous to each other, that's always kind of preferred, I guess. But if the parties don't want to be courteous to each other, you don't have to wait for one state attorney to tell you, set the deadline.
Okay.
Mr. Devens has now been in custody for 2,202 days, okay? And if one state attorney is not available, maybe one of the other two assigned to this case can stand in. And if all three are not available, maybe one of the other 150 state attorneys upstairs might be able to sit in. But
Sheesh. He's saying they got 150 state attorneys upstairs. These motherfuckers need to get working. They're not delaying this trial no longer.
The other issue has been is that Ms. Liberty must properly coordinate and must properly notice the state. This is a I know, but
I just read the rule. She doesn't have to coordinate anything. She has to make a good faith effort.
Right,
to
she
try.
has to make an effort.
She has to put a
coordinate.
certificate on the bottom that says, I tried, they told me no.
So what has happened in the past is that she has asked for dates, we provide dates, and then she schedules dates out or times outside of those.
Judge, he's actually lying to the court right now. I printed
Stop.
out every
Please,
email.
please, stop.
She's saying he lying, man.
You all feel that that has been submitted
We'll file for
in error, you file the appropriate motion, and then what would be a wonderful use of this court's time is I'll have a hearing with 6 lawyers, 7 lawyers, because you all can't say no. So in case I'm not making my feelings on this point clear, I'm not prejudging anything, but talking to a judge about trying to agree to set depots in a death penalty case is absurd. And I'm embarrassed for both sides. I'm embarrassed. The motion for scheduling order is denied. You don't need a scheduling order. Set your depots. I'll enter the appropriate written order. Next.
Yikes. Bro said y'all don't need this shit. This is embarrassing.
And his third motion to control the forensic images of the cell phones belonging to Christopher Thomas and Anthony Williams. I read this motion. So State, let me start with you on this one. Do you have anything from the cell phone downloads of Christopher Thomas and Anthony Williams that has not been turned over to the defense at this point?
Judge, again, this one is Ms. Buckaloo's purview, so she filed a written response. I think the issue that Ms. Buckaloo had, and I'm probably going to be speaking out of turn on this one, is that there are contents of the phones that are not relevant to the case. And so some items have been turned over, but not all the items. This is one where I am lacking of knowledge.
That's okay. The state doesn't get to decide what's relevant and what's not relevant. These are the homicide victims, right?
Yes.
Just turn over everything.
Well, Judge, I can tell you, because I'm a part of it, it's not necessarily we have to turn it over, we have to make it available for inspection. We
Yes.
have a number of dates, we
Okay.
scheduled that, we told them they can come again. There were multiple days when we sat there and waited for their investigator, came hours late.
She's lying again. So I'm
If I may
gonna,
finish, Your
Hold
Honor.
on.
She's lying. So this is about Sack Chaser and Juvy's phones, the deceased victims. Their phones were in the car. Defense just wants a copy of their phones, like the download of their phones. State just said that they've tried to schedule it and the defense is always late or not, doesn't come or something.
she's lying again. So I'm
If I may
gonna,
finish, Your
Hold
Honor.
on.
I was the one who was personally there that day with him and our investigator. We continue. Anytime they want to come see it, we have had an investigator from our office, the computer, and their investigator there. Sit
Is
down
this something where they
anytime
can
want.
just stick a thumb drive in and download what you got and that's it?
Make a copy of it? No, Your Honor.
they're
Why
withholding
can't
it.
they do that?
As Mr. Griffin said, Ms. Buckler is the one with the most knowledge of all the contents of the phone, and that's why it's all discussed in her response. But regardless, the state's obligation to make it available, we have and continue to, anytime they want to
But make it
schedule.
available, one of the things
For
to make it
inspection.
available for is to copy it. They're allowed
If
to
it's
copy
available
it.
to be copied. Ms. Buckler, and that's why I did this one of the motions, we said that she would be prepared to argue, is of the opinion that she
You
filed
already
the
went
whole.
to trial. You
Exactly
already went to
right.
trial?
And it was
You already went to
withheld there.
trial.
Yes,
This is the decedent's cell phone. Okay, over the state's objection, This motion is granted.
W. I said this in my last video. I was like, just hand it over. It's the victim's cell phone's copy. That's very important evidence. This is Brady evidence. Thank God he figured it out and went through the weeds there and was like, you already had a fucking trial.
Make the appointment, go over there, download everything that they have.
I will get my expert to do our own download
Okay.
of the phone. So where we need the parameters though, so when.
There's no
where-
parameters, just make an appointment. Listen, I'm not gonna make appointments for you.
Okay,
If you all can't work that out, I don't know what to tell you. Okay, go appeal to the 4th DCA and say, we can't make appointments and treat each other like civilized human beings when we have to come over and download.
He said, listen, I ain't making no appointments for y'all. Y'all are adults. This is a professional environment right here.
For over a year, and nothing's been done, that it does not qualify as an ongoing investigation. In addition to that, that they are obligated and they cannot hide behind the open investigation provision when it deals with information on charges against Mr. Demings, specifically the murder and the tampering case. And they indicated that the tampering case is somewhat going to be used in the murder case, as I think they said, consciousness of guilt.
Oh yeah, I remember I read that. They said since Melly was trying to keep his girlfriend away from court, allegedly, with the coded language notes through another inmate who then told Bortland over the phone, they're saying that's consciousness of guilt, and they want to show the jury that in the murder trial.
I know the court has told us to talk to Mr. Demings concerning the potential conflict, and they have alluded to the conflict today. He doesn't know how to make that decision because he doesn't have sufficient information to determine whether or not he wants to keep Miss Liberty or any of us. It's more like 14 months that they've sat on this information.
State, listen, for the most part, I agree with what Mr. Avison just said. You have a continuing obligation, so you do agree anything that comes from any source that is relevant to the charges against Mr. Demings, you gotta turn that over, right?
Before we get to, yes, Judge, there is an ongoing obligation for things relevant to his homicide or to his open tampering charge that would be turned over. Having said that, Judge, we weren't noticed for this particular motion today, and we would rather have a full response. The notice says motion to compel. We didn't actually receive this with Miss Liberty's pleadings. This one actually came separately, and we only received it, I think it was 2 days ago.
214 that was filed. And
And honestly, it says motion to compel. Ms. Liberty has filed so many that we were unaware that this was going to be argued today.
Let me hold on that. All this stuff belongs to Miss Liberty. Has she asked Apple to just give her a copy?
I believe her lawyer did write a letter asking for the return of all, and they said they would give you nothing.
They're not gonna give her her own thing?
Nothing.
so let me just.
So Apple won't give you your own stuff?
They said Borough Sheriff's Office. Apple then did sit with me. I went through it. I have access to the iCloud, but no, they will not give me the return of what they got.
But you have access to the iCloud that has all your stuff on it?
Of course, that's just my iPhone.
Well, in that-
It doesn't matter. They have it in
No,
their
no,
possession.
listen, I don't disagree with you, but you all are a little more adroit in these technical matters than I am. There's nothing that's outside of what's in her iCloud. Everything's in it.
I don't know. I don't know what they've seized, because I believe there are additional search warrants based upon the original search warrant.
Well, I don't know anything about that, but as
I
far as the
understand.
search warrant, I already ordered you to get that, you got it. As far as police reports,
State didn't respond to that. Is there more search warrants we don't know about? That's the vibe I'm getting from that non-answer right there.
It's still an open, it's still an open investigation, Judge.
Judge,
I disagree with that pursuant to Florida statute, but there are no police reports.
There are no police.
Because nothing's happened.
No.
Okay, so there's no police report. The names of any witnesses and all witness statements related to the Apple iCloud, that would be like a custodian of records, right? Now, there's no other witnesses to iCloud except a
Correct.
custodian of records.
It would be Apple or their records custodian certification.
Have you listed a custodian of records?
There's nobody to know, Your Honor. We have not listed
Not.
either the homicide or the tampering case.
So you would have an ongoing obligation to do that.
We
if
have-
you wanted to use any of this.
We have an ongoing obligation to turn over anything that's relevant or may be relevant to either of those two cases. We are complying with our discovery obligations.
This is what I'm gonna do. Now, go ahead, sir. I'll give you the last
I find it hard to believe that there are no investigative police reports saying they've contacted witness A, witness B to verify or to corroborate whatever is on, whatever they seized pursuant to their original search warrant. I find that hard to believe.
That's a great point. That is bullshit. That is horseshit for sure.
A year, they come in here and file a motion indicating that Miss Liberty must get off the case because of the conflict. I find that very hard to believe. And I find it hard to believe that they, in their investigation, did not take statements of potential witnesses. And they say it's interrelated to the murder and tampering case. So
Well, I mean, listen, they're under continuing obligation, okay? If we get somewhere down the line and something is put before me that they had material sometime long before February 8th, and Mr. Griffith is standing here and telling me otherwise, he's gonna have a very large problem, right? A very large problem. So I'm not playing with it.
and I appreciate it.
So at this point, I have to take everything at face value.
Then
But that being said, I'm going to grant your motion in part as follows. State, I'm going to give you 20 days, turn over anything that you have received regarding the Apple iCloud of Raven Liberty that you intend to use at either trial, okay?
Damn. He only gave him 20 days to hand all that over. I wonder if they even found anything on there. I mean, it was just about Danny Polo's identity being leaked because of his own wife. It was pretty easy to find by anyone that could do a few Google searches.
Make it as detailed as you can, because if we get forward to the point of a trial and they stand up and say, Judge, they didn't disclose this and now they're trying to use it, you will not be using it. It will be barred as evidence at trial, okay? In the Apple iCloud, download that you expect to use at trial in either case, in Mr. Dennett's case. All right, and I'm basically ordering you to comply with the rules, which you already should be complying with. Well, he has to turn that over,
Okay.
whether it's in the affidavit or not, whatever it is. He has to, as it relates to Mr. Demings, he has to turn it over. As if it only solely relates, if Miss Liberty, if they're, I have no idea. If they say Miss
The judge, I have no idea.
Liberty went and did X, Y, Z with witness A, I don't know how that wouldn't be considered as relevant to the case. If they want to introduce that in the trial, nope, then they're going to have to turn it over within 20 days. So I think you're going to have your answer
We'll
in
see.
20 days.
We'll see what the response is, and I'm sure we'll be.
In light of these allegations that I'm, I guess, trying to murder or take a hit out on Danny Polo, it's came to my attention that Danny Polo might be suffering from some type of mental illness at this point. We heard in the last trial, he thought somebody had a hit out on him. He had lied to the court. We found out he had pictures out there in the public domain. And now, 2 years later, I'm being accused of trying to kill Danny Polo. I don't know exactly, because we don't know the affidavits, but it's a homicide detective, and it's Danny Polo's picture, and I'm directing gang activity. I think at this point, Mr. Detective Polo is in need of an evaluation to determine if he even has the capacity to sit and testify.
Wait, I didn't know the accusation for all those search warrants were her attempting to kill him. I thought it was just leaking his identity. Is that equivalent to trying to murder him because it could put him in danger, I guess? She basically just said this guy might have some mental issues and may have some shit going on in his head that's not there and be paranoid.
In this case or any other case, because he has some type of paranoia about being murdered at this point. That's where he's going at a defense attorney, saying a defense attorney is trying to murder him now. Because that is the premise of this so-called investigation, is I'm trying to kill Danny Polo. That's the witness that they're saying I'm tampering with because he was impeached, not once but twice.
The request
Is that he undergoes a psych evaluation before he's allowed to testify further in this case.
I think, because I don't entertain an ordinance motion, but I think you're talking about challenging the competency of the witness, correct?
Oh, yes.
Okay, so I think if you have that concern, I guess you need to file the appropriate written motion.
Thank you, Judge.
Okay, anything else?
Dude, what the fuck is this trial? And now he's about to talk about the porn? because they don't want anything else on Zoom anymore because there was a porn leak in the Zoom.
Expand that order level to allow her only to appear on Zoom.
I would be happy to allow all the lawyers to appear on Zoom, but based on what happened, which is what caused me to enter that order.
What I think
I would need to know, because all of your names are out there in the public domain.
She's just asking for Friday for the hearing of Mr. Barris as to
Sure.
the Mariah Hamilton motion.
But even going forward, the court can limit people who come in and can only just allow her in, and forbid everybody else from coming in.
I completely agree with you, but based on the creative nature of the viewing public out there, if I get 7 or 8 or 9 people that all sign in on the same name, then I'm not quite sure how you want to handle it.
Well, we can verify which account Ms. Butler actually is. That's the case.
I would.
I'm sure there's a way to make a Zoom call secure, right? Like, what fucking year are we in? COVID was 5 years ago. This fucker hasn't figured this out yet. All right, that's it for the day. And there goes Melly right there, smiling at the family, going back to the same jail cell he'd been in for 5 or 6 years. Sorry, it's not. It's actually not funny, but I'm laughing at how absolutely fucking insane that is. Yeah, that's pretty much it for today's video. Apparently, there's a hearing on Mariah Hamilton on Friday, so I'll cover that too. Melly's girlfriend. She is an important witness. Comment your thoughts. Hit subscribe right now. Love you guys. Peace out.